there's a reason why there are two different courts, right? There's a reason why there's a family court and a criminal court. And what happened here was criminal conduct. What happened here was harmful to this child. And our task here is to protect this child and ensure that justice is served.
Case number 12C348747-1, State of Nevada versus John Woodruff. Page number 13C348747-2, State of Nevada versus Destini Woodruff.
Good morning, Robert Draskovich on behalf of Destini Woodruff, who is present at liberty.
Morning.
And Your Honor, Schneider on behalf of John Woodruff, he's present, Your Honor, at liberty.
Good morning.
Good morning, Your Honor. Lindsey on behalf of Michelle Joby for the state.
Good morning.
As to Ms. Woodruff, we're on calendar for two things. One is an entry of plea. There's a correction that needs to be made in the plea agreement. We're going to ask the Your Honor set that for 2 weeks in order for the corrections to be made and for her to go over them with me. We have a second matter, and it's concerning restrictions of access to her children. I'd like to be heard on that this morning.
That is correct, Your Honor. I would also point out, I do believe that we are continuing the co-defendant's plea as well because they are contingent pleas for 2 weeks.
Yeah, thank you, because that was going to be my first question. Mr. Schneider, is that correct for your defendant as
Good
well?
morning, Your Honor, Schneider. I'm not sure if I did that, but Judge, I'm here for Mr. Woodruff. Judge, there's also a minor issue on our guilty plea agreement. The wrong department is on there, and it's obviously clearly not this deputy's fault, and certainly not Michelle. She's in trial, so somebody made some Scrivener errors. It probably should be corrected, Judge.
Okay. So 2 weeks for entries of plea,
October 18th, 2022, 8:30 a.m.
and then on Miss Woodruff, I did review the motion to modify conditions of release. Not a lot of information in there, but does the state want to verbally?
Did Your Honor not get the written opposition?
Oh, well.
It was filed on the 30th.
Bear with me. Maybe I did and I forgot. Ah, I did. Hold on. And I did review that, actually. Bear with me. Let me, yeah, I even have notes on the opposition. So. Yeah, so I did review this yesterday, too. Okay, Mr. Draskovich.
Thank you. I intend to supplement the record somewhat. There was reference made in the state's opposition that she wasn't involved. And we have concurrent cases pending. I mean, there was the criminal case, and then there's the case before Judge Gibson, which I was not involved in. It was, Division of Family Services. My client actually actively participated, went to all classes, and completed all requirements. But the state, and obviously the state has an obligation to try and reunite a child with children with parent. There was just a general state, no contact order, which is very common in criminal cases. You look at the date of the entry of that order, it was May of 2020, so we're looking, 2.5 years back. She's not asking to have unfettered contact with an 8-year-old and a 9-year-old. She's asking basically over the supervision of this other district court judge whose area of oversight is this very issue. It's not healthy for anybody. I mean, we're kind of in a procedural no man's land. Her criminal case is being resolved, but for correction that needs to be made in the plea agreement. Meanwhile, the clock's ticking, and there's a presumption, for termination of parental rights, or likewise given this long of a no contact order. So we're asking. And it wasn't made that clear, I guess, on either side. We're asking for Judge Gibson for them to reopen that case and to have this general no contact order lifted and just allow whatever contact, visitation, supervised visitation to be under the other district court's orders to allow them to proceed with hopefully a process of reunification. And I would submit that our request is, it's reasonable. So.
Thank you. Anything from the state?
Yes, Your Honor. Like I indicated before, I am covering for Ms. Joby, so I'm not acutely aware of the procedural specificities of this case. But I can say, in reading our opposition and understanding the argument of defense, there's a reason why there are two different courts, right? There's a reason why there's a family court and a criminal court. And what happened here was criminal conduct. What happened here was harmful to this child. And our task here is to protect this child and ensure that justice is served. It's my understanding we would have entered that plea today, but for the incorrectness of the GPAs. But that being said, that guilty plea is said to be entered within 2 weeks. At that point in time, I think this is certainly something that can be addressed when we come back for sentencing, when we've gone through a PSI, when we know a little more about this person. But based on what our role in the criminal court is to protect this child, and in terms of reading this report, it was definitely offensive to the state. We think we are still in the position that it should not change, that there should not be contact pending actually sentencing and getting this case moving forward. I can't speak to the presumption against termination. That's not my area of law. I can't speak to that, and I wouldn't presume to. But I do believe that our opposition speaks for itself. I would stand by that, and I would request that Your Honor not change the no contact order.
Your Honor, may I weigh in just for a moment, please?
Well, you should have done that at the start.
Your Honor, I don't think that he has any standing to weigh in. It has nothing to do with his client.
Although I attended those initial hearings at family court, Your Honor, and it's very common practice for the district court, criminal court judges to defer to the family court judge's orders on visitation and contact.
So doesn't that, though, beg a question in terms of, I don't have a family court order in terms of contact other than a parent? Well, as I sit here right now, I gotta tell you, I didn't look up the family court case. I don't have any details on that. I mean, for better or worse, the motion being essentially a paragraph long.
We would ask then, and I was surprised to see an opposition from the state, but why don't we address this 2 weeks from now? We can supplement the record if need be. I want Your Honor, obviously, to make a decision. Okay.
Yeah, let's do it. Continue the hearing on the motion to modify conditions of release to 2 weeks from now as well.
October 18th, 2022, 8:30 a.m.
And what we had wanted to do is basically get the ball rolling in this aspect of the children's life and her life. So
yeah, so, I mean, you get a reply if you want, and you can add, details, and the state can verbally respond, and see you all in 2 weeks.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.